All right, we'll call to order the meeting of the Zoning Board of Review for today's date, Tuesday, March 25th, 2024. Roll call, please.
Mr. Najarian?
Oh, I'm sorry, 2025. Here.
Mr. Marston?
Here.
Ms. Benoit?
Here.
Mr. Marcantonio?
Yeah.
Mr. Gill? And Mr. Savini?
Gail Berlinghoff had recused herself.
Okay.
Item 3, disclosure of no compensation or pension credits received by board members. We're all appointed by the town council. Item 4, disclosure and notice. Zoning Board of Review members shall disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning the merits of any application before the ZBR. Item 5, approval of the minutes from 2/11/25.
Make the motion to approve the minutes.
Okay, they were distributed well enough and they were brief, so we have a motion to accept. Second?
I'll second the motion.
We have the second. All in favor? Aye.
Aye.
Approved. Okay. And we'll move to item 6, which is the continuance of ZBR 2402, applications for a special use permit for the property located at 44 Railroad Street, North Smithfield. Owner of the property is Four Sons LLC. This is lot AP004, lot 87. Applicant is M&M Transport LLC, seeking a special use permit in accordance with 9.2 special use permits. Also seeking relief for section 5.5.2, non-residential district, North Smithfield, to have less than the required side and rear setbacks, which requires a dimensional variance. This lot is in the M zoning district and falls within the water protection overlay district. So, we were given additional materials as a function of the continuation of the initial meeting. We can enter those in to evidence, but I have some significant issues to discuss on my behalf as the chair, and members can join in accordingly. This application for the zoning official, are we keeping the original submission, and these will be in addition to?
Yeah, it's a continuing.
Okay, so the application never stopped. This is just as we say. So I think we stopped at 13. 13. So what I'll do is I'll introduce the additional evidence into the record, and then I want to address the application, because I think I don't want to waste anyone's time, you're professional, the owners, whomever is here, nor do I want to waste the board members' time. In the interest of trying to get to a point where a lawful decision can actually be made. So I think we should probably call the application P1A, just so there's no confusion. So that would be P1A is the new application, which is ZBR 2402. I was going to call P14 the letter from Coneco Engineers and Scientists.
Should that be 2502 versus 2402?
I don't know. Should it be 25 or 24? I think it is 24, right? Yeah.
Because it's a continuation.
So it's from Coneco Engineers and Scientists, dated March 3rd of 2025. It's addressed to myself as the chair of the Zoning Board of Review, and it's regarding the case, of course. And that's Multiple pages, it's probably, it's 3 pages of text, and then 2 with calculations and a engineer stamp, Thomas Hevner, registration number 11597. And he dated his stamp of 2/25/25. So that's P14. P15 is also from Coneco, dated March 4th. That's 4 pages. It's signed by Damian Dimitrick, I'm sorry, and Brian Kinglinger. This address is again addressed to the Board of Review, and my name is the chair, and it addresses, I believe it addresses the memorandum that the attorney who represented the applicant the last time requested that I provide him, which was a summary of all of the questions I had asked him. So you responded in kind. That's just the announcement. I didn't label that. I missed that, so we'll get back to that. P16, I'll call these 2, the aerial, it's titled Project Site Work Aerial Image Comparison. At the bottom in parentheses is a date of 2023, so we'll call that 16. It's 2 pictures. One has superimposed some shrubbery or plantings of sorts. P17 is some sort of a map. It's a surveyor's map, National Surveyor. It's not specifically legible necessarily. I think it's dated 2/15 of 95 in the bottom left corner, and it's a site plan of the property. 218 would be the abutters, P18 would be the abutters list. That's a single page, and that was dated March 13th. And P19 would be the 200-foot abutters map, dated the same 3/13 of 25, by CAI Technologies. Okay, I think, did I get everything, everybody?
Did you get this map?
No, that's next, it's over here, yeah. I was gonna go to that next, the drawing is right here. I had a bigger version of it, so. So this is actually, I have to change the number on this. This is P20? P20 is site improvement plans, terminal site improvement permitting plans prepared by Coneco Engineers and Scientists of East Bridgewater, of Bridgewater, Mass. It's 4 pages, including the cover sheet, so there's, 4 pages. There is no date other than the signature date of the PE who signed it, so the only date we can reference on the drawing, I don't see one, it's usually in this box, would be 2/27/25. That's when these 2 engineers appear to have signed and stamped it. One is, oh, there it is. I missed it. It's right there, but it's usually in the box. That's why I didn't see it. I'm sorry. Thank you, Mike. February 27th of 2025 is the date, but again, it's not in the box, so I apologize. So that's that. So that drawing shows, multiple things. I'll have a smaller version of it. There's a big version here if you'd like. So what I'd like to do is try to bring some clarity to the matter here. This has been quite an exercise, and I think there's a little bit more confusion here than there needs to be. I don't want you to, let me go through this list of issues, and then, because my conclusion at the end is that we need to continue this, because we don't have what we need, and frankly, I don't think the process is being followed correctly. Members, as you see fit, certainly interject. On the application, for example, it's, you may look at me and roll your eyes and say it's highly simplistic, but if we want to stay by the rules, it's as simple as you didn't put the city under address. It says Coneco Engineers and Scientists, 45, 4 First Street, doesn't give the city. The reason I make note of that is because we have other documents in here where an official letter sent to the town of North Smithfield was addressed Smithfield. So some can laugh and say, oh, that's funny, but when it's a legal document, and this is a legal document, the lawyers will tell you that every little thing matters. So that needs to be corrected at some point prior to the next meeting. I noted on item 2 that for the second time you've listed lot coverage as 24%. At the first meeting, I mentioned to Attorney Mancini, and of course, you've now submitted it twice, so therefore, it has to be factual. The exemption for 6.19 is 20%, not 24. So simply by interpreting those two numbers, there is no exemption for the water overlay. We have defined, even though there's some ambiguity, but there isn't now, but we should make it crystal clear because the drawings contradict. You are asking for relief based on, one of the issues of relief is based on accessory use for the fueling facility. I think that's understood and clear, but again, it gets a little muddled as the waters flow down the river. Item 10, number 4, item 10. Again, I assume you inserted that for general information purposes, but the reference to the wells, monitoring wells, this board has no jurisdiction whether you put in 5, 10, or no. So I don't think it needs to be there because again, it obfuscates and takes us off the center mark, which is the simplistic definition of what we're trying to do. So that should be stricken, in my opinion. The board can make a motion in accordance. Item 5, which is number 12. Again, I guess for either your own benefit or to try to simplify matters, you reference 6.19. And as you should know, and I assume you do know, this board no longer has any jurisdiction with 6.19. So all you're doing is confusing matters by inserting it into the application, is we can't grant you any relief with regard to that ordinance. 9.2, you mentioned, make reference to the special use permit. And it kind of troubles me that we all know, and you don't acknowledge it in writing, that one of the basic premises here is that you violated the terms of the standing binding special use permit that goes back to, I believe, 1996. It might be 95, but we know what it is. You make no mention of the fact that you violated the terms of that special use permit in the application. And I think that I don't mean the narrative, I mean the application. Did I miss it somewhere?
It's
Where?
in 12. On the item 12, it's the 4-25-1995 ZBR decision stipulations 2, 3, 4, and 5.
I don't have that. Where is it? On item 12 of the main application?
Small print.
Yeah, okay. Well, that's not, there's so much writing there that I've read it 6 times, but that's certainly not descriptive enough, because that is the crux of the matter. The decision specifically said, do not improve. You did, your client did, and that's one of the things you're asking for relief for. So of all the things to minimize, that's not it. It should be crystal clear what is being asked for. And we should also note, if you didn't, but it's probably listed there if you break it out in the application, you should note that the buffer is also part of the violation. The buffer was not supposed to be removed, that southern buffer. Now, I know that drawing shows, one of the pictures shows some arborvitae or some kind of large planting. But the notes from the SUP clearly says that there's a buffer that needs to be maintained on the southern elevation, but that no longer exists either. So all I'm saying is, when you update this, you need to clearly state that the southern elevation was in violation and the rear work is in violation, because that's what you're asking us to override. 6.19. You know, the basic issue here, and I understand, I think all the members do too, I think they can conclude that the reason you put it in the app is because you believe you're exempt. But with all sincerity and all honesty, I've read the old document, the new document, and it comes down to the simple fact that while, yes, your address was legal prior to the rewrite of 6.19, the work, as it sits there as I speak, is illegal. So I don't see how any reasonable person could say that work performed illegally could then either be vested or asked to be grandfathered to avoid complying with the current law when you disregarded all the other laws by building something illegally. The current 6.19 clearly says there are exemptions, but it also states the very first words say, any lawfully established use. And we all know by definition, by sitting here, the use is not currently lawfully established. Any exemptions with regard to the percentage also don't exist, because twice you've indicated that you've got 24% and the ordinance says 20. Item 2 of the exemption indicates lawfully established use that does not result in a net increase of impervious area, and clearly you have increased the impervious area. So there is no question in my mind, and I will defer when the time comes to the members to get them to say yay or nay, that this application, this use requires a special use permit that you may or should know is now in the jurisdiction of the planning board. This board does not handle it anymore. So frankly, this application should be held in abeyance until you go to the planning board and apply for a special use permit for 6.19. And if you feel strongly that you don't agree with our interpretation or my interpretation, then you can get the planner or the planning board to send a memorandum to the zoning board of review officially saying that you are exempt. If they say that you are exempt, then I don't think we have any issue with it, because they are the authority. But I have every reason to believe that you're right on the banks of the river, and by every other definition, you need to get a special use permit. So anything we do today will be a waste of your time and ours, because whenever planning board relief is required, it's, as you should know, may know, it's gone, you go to the planning board first to get that relief or approval. This case, it's a little bit of a nuance, because now they have the legal authority to grant variances and special use permits. But they still, in this instance, because that's what we've always done, the applicant goes to the planning board first. And because 6.19 is such of such critical importance to so many in this town, I see no reason why we would break that standard. You should go there, get your special use permit. If it's granted, then you come back. So and that's why I think, without question, this application needs to be continued or put in abeyance or parked, whatever the proper legal terminology will be, until such time as you go to the planning board and come back. In that light also, for the zoning official, I was still a little bit, I don't want to get too far off the track, but I was a little bit confused as to why this application doesn't fall under the definition of the, you know, the UDR there, Unified Development Review. Was that ever discussed with the planner as to whether they, in fact, could handle this entire affair or matter?
I don't think it was. I think he was gonna try to handle it with a letter. I don't think it was discussed.
Okay, so I would defer also to the planner. If he reads, you know, it's right here, you know, this is the law that was established in January of '24, which gives the planning board extensive jurisdiction or far greater authority than they used to have. So I guess at some point, the planner should look at this application and decide whether it meets the requirements of this UDR, such that the planning board could take this case application
make
in
the
its
zoning-
entirety.
Yeah, I
So
think they can make a zoning
That would be
decision,
his
too.
decision to make, the planner, and you're free to engage him. So that needs to be flushed out by all of the parties. And the other thing that's a little bit kind of frustrating also is that item 6, which I think is also in the application, you make reference to the non-conforming building for the 40-foot side setback, but it's really not relevant, because you're not talking about a 40-foot setback. You're talking about a 10. So the application, again, needs to clearly state that the accessory use setback is 10, it's not 40. Because all we're doing is muddying the waters, and, you know, this board has always tried to keep everything crystal clear so that anyone who chooses to appeal, or whether they appeal, they don't appeal, if you look back at it in 5 years, you don't need to wonder and use a Ouija board or something to try to figure out what was being discussed, okay? And you should also note that this should be investigated, because it's right here. Under accessory use in 6.8, it also says very clearly that you've got that 10-foot setback, but it says side, 25% of a side or rear yard setback. It doesn't say the property in its entirety. So it says the accessory use may cover up to 25% of, again, the side or the rear. So you need to show, when you update your zoning map plan, that with regard to the accessory use, that use and the tank and the pads do not occupy more than 25% of what would be the rear of this property. And again, I'm reading verbatim from the ordinance itself. You know, I would also note that on the drawing, you referenced the septic and the distribution box. I mean, you can keep it, but again, it's of no consequence to us. I would just hope that a permit was pulled for that work, all due respect. But it's not relevant, as you know. And then the other thing is, I think, again, since I saw it, I'm not going to not comment on it, but, you know, you also show that the catch basins, which were never properly defined the first submittal, and I requested that they be, discharge off your property, which, you know, again, it's not our jurisdiction, but that's a clear violation of DEM, and it may even be federal, but that's for you. You showed it, so I just, now, sheet 4, again, it's very confusing, because by mistake, or, you know, I don't know what else you want us to think, you show the 40-foot rear setback. We can read the map, we see that the property is only 42 feet wide, and you conveniently don't show the side setbacks. And obviously, if we came in 40 from the left and 40 from the right, there's only a cigarette width of 2 feet left. But then, it's not even relevant, because you're asking for accessory use of 10. So why that drawing serves no purpose for us legally because it's not correct. I mean, we're not judging you or ruling on 40, we're ruling on 10. So the drawing has to be corrected because we're not going to look at a drawing after all we've been through with 25 different revisions and resubmittals and say, well, he meant to say this, but he wrote that. You know, it's stamped, it's a legal document. I'm a little bit surprised that whomever stamped this didn't pay attention to the fact that you're not even telling us what we need to know. So then the other issue that I have is, it's a compelling question, which I'm assuming, you know, the board can interpret. We could defer to the zoning and the building official, but we're talking about an accessory use, not just an accessory structure. You agree? The tank is a structure, but it has no use without the associated pads. If the trucks don't pull up to the tank has no use. There's no purpose for it to be there. So another question that we need to look at is the fact that you don't show us whether the pads are in or out of the 10-foot setback. If they're in, then there's additional relief that you need, because I think it's reasonable to conclude that the intent of the rule is to keep the use 10 feet from the lot line. And a truck parked filling is not, that is within the 10-foot, would need a variance. And if I just use my eye and I look, I think it's likely that both pads are within the 10-foot setback. So you see that the mountain is getting higher to climb. But in fairness to us and the people watching and to you, you know, when we make a decision, it's going to be based on the facts. And if you need 3 variances, then you best apply for 3 variances. If you need 2, then you best apply for 2. And you need the special use permit that allows you to break the rule of the decision of the previous zoning board. So I think you understand all of those. You're the engineer, I'm sorry.
Yeah.
Okay, I apologize. I think it's all straightforward, and I think it's very reasonable. And I don't think we need to, you know, use your time to, you did a very good job of whoever wrote those memorandums. They're very concise, and I think for the most part, they address most of the issues that we raised, but I don't know that it's productive to rehash that or let you explain what you wrote, because again, it was well written. I'm strongly suggesting that we need to continue the application regardless. That's my opinion, for the reasons I just listed. But in addition, I'll ask council if we need an actual vote to remand it or to send it to the planning board for their review to see if 6.19 is applicable.
No, I don't think you can remand it. I don't think you have the power to remand it as a board, but following that train of thought for a minute, there's probably 4 options you could do. One of them is you just approve everything, which you're not inclined to do tonight because of the information and the list that you laid out. Second would be to deny everything outright. The third would be to grant conditionally one aspect of the relief, which I'm not sure you're inclined to do, say the dimensional relief, and then to take the special use permit and direct the applicant back to the planning board for an application there, which would be called a, jot some notes myself, development plan review. This basis of getting this thing developed. I want to write that down, development plan review with the planning board. Or, you know, you could grant relief and make it conditional upon removing a certain percentage of the 24%. And I know you're not gonna go there, but I want to put that out there.
Yep.
But to go back to your question, I don't think, you don't have the authority to remand, but I think what you could do is what you started with, which is table the application and let the applicant reach out to the town planner and ask, and talking to the town planner, if they think that they should submit a plan for the development before the planning board. Now becomes rather tedious and detailed, as I think the board well knows. And that type of a plan, as you guys know as engineers, is gonna address every one of these things, but before a different board, because that's where the jurisdiction now rests with special use permits. You're in a unique area because of the sequence of facts and how this happened, you know, the 95 issue, the conditional relief, the later expansion of the non-conforming use to this impervious lot that was covered, and now you're coming asking for relief from a board that you wouldn't typically be asking that relief from. And, you know, the chairman's being really deferential in wanting you to have the information you need to address these issues before they make a decision. He's giving you the flag that you need to be before the planning board for that issue. It's just we can't remand it. So I guess procedurally, the best thing to do would be to, you know, you either take a vote and you deny it, which I don't think you want to do to the applicant. These guys are here in good faith, and if I'm hearing you correctly, you don't want to do that. Or if you certainly, looks like if you were to rule on it tonight, I'm not speaking for the board, that may be the direction it's going. But if you were to table it, then you'd have the opportunity to reach out to Mr. Carullo, deal with the town planner, have a follow-up conversation between him and Mr. Cody, and be able to see about a development plan review and what the issues are that you need to address. And then you could table it, and then after you get the information you need, you could come back and contact the town, and we could set a date for you to come back before the board, if that's the path you go down.
Well,
What are your thoughts, Mr. Chairman?
yeah, to follow up, yeah, I mean, all you have to do is look at the record. This board goes out of its way to try to be fair to all parties, whether it's business or private. We look to follow the law, but we look to work, when we can, to work within the parameters. So, and we also can't rule properly with what's in front of us today. And, you know, I'm sure the attorney would tell you that if you insisted that we rule, yeah, we can rule, but we'll rule on what we have, and I don't have to paint the picture for you. That doesn't mean that you're going to infer that if you do all this, you're just wasting your time. We don't like to play games with people, but you have built a wall that's very high, okay? And you did it of your own accord, and you did it in the face of a cease and desist order where you said we will proceed at our own risk. So all that being said, we are giving you the opportunity first to go and get the 6.19 compliance. And then if you succeed in the 6.19, to resubmit everything that properly shows what is and exactly what relief you're asking for. And I think the board is probably of the mindset that the aprons or fueling pads would be considered part of the use, because without them, the tank serves no purpose. So if it means that you have to eliminate the south side or the north side and only use and get relief from one or the other, then you need to come with something reasonable that is accurate, that gives us something that we can hang our hat on, okay? And yeah, we take very seriously what previous zoning boards have done. So you know, there was the right way to do this and it wasn't done. So now all you can do is try to work with us to get to a point where if we can find a common ground where both parties, the town can be protected and the applicant, even though they overstep their bounds, can find some use for the monies that they've spent, then so be it. We're not making any promises. So I would suggest that either we make a motion or we just give you the direction that if you accept on the record that you're going to withdraw the application and go to the planning board for, at the minimum, the 6.19 review. If the planner gives you a letter that says you are exempt, then you can contact the zoning official again and we can reschedule.
If I may, Mr. Chairman, a table is really, it's a little bit of a slang, but it's a term of art for when you're taking motions before the court and you don't do anything, you don't act on them, and it gives you an opportunity to either take a different course of action or no action at all. If you withdraw the application, you're no worse off than you are right now. You haven't been denied, right? If you get denied, you gotta wait a period of time, or you gotta appeal it to Superior Court. You don't wanna be in that movie. So the chairman's giving you opportunity here that if you withdraw the application, you go back, see about the development plan, talk to the planner, see what he thinks about the course of action, because the board doesn't have the authority to send you there. You follow me? Go, you have a question?
Rich, I'm sorry, just introduce yourself again, or for the first time.
Damian Dimitrick, Conoco Engineers and Scientists of 4 First Street, Bridgewater, Massachusetts. Here on behalf of M&M Transportation, here with Brian Klingler of Conoco Engineers and Scientists as well. So as far as the discussion that's gone forward so far, my, I guess, question as far as the withdrawal versus the tabling of the said project, right? I don't want to necessarily withdraw the application, and I'm not arguing against us having to go back in front of the planning board. Would tabling said project until we are able to go in front of the planning board, or do we have to withdraw for that to occur?
I think it's a nuance. I think council just tried to give you your.
Yeah, and that's,
your-
I
yeah.
just want to understand appropriately.
I mean, I don't know that either one of them reach a different remedy. I think that if you were to table the application, which really in a sense is a form of withdrawal, then if you decide to take it up again, you'd have to advertise and you'd have to pick a date certain. I mean, what I think you can't do right now is just, you could, but I don't think you should, just continue the application out, right? I don't think that's the right remedy here. I think you either should withdraw the application. I mean, if you table it, it just sits there with no date certain anyways. Are you thinking about the difference between the notice requirements and all that? Is that what's going through your mind? I mean, if you were to table the application and you pick a date that you're gonna put it down for in the future, you have to advertise. If you withdraw the application, you resubmit it, you have to pick a date and you have to advertise, right? Unless I'm missing something, and doing this for a long time, either one of them, you're gonna have to put it in the notice requirement of the public venue and advertise it.
And you might note that, unless I'm wrong, the reason to withdraw, with no prejudice, is that if the planner reviews it and interprets this as being applicable to the UDR, Unified Development Plan, or the PBR, then you would never come back here.
You may not come back here, you can grant all the relief.
Because they have the authority, depending on their interpretation of your case and this document, to handle everything. So at that point, you would withdraw because you're not coming back. So withdrawing is,
As the chairman told you at the beginning, there were major changes in Rhode Island to the way that we handle matters for special use permits with the planning board, the zoning board, and the authorities, the overlap of authorities made, without getting off on a tangent, and I'm no expert in it, although I'm familiar, the planning board now has plenary power compared to other boards in the zoning board with issues of special use permits. And so that is the proper board. If you were applying now, that's the board you would be before. And they also have this collateral authority to be able to grant variances in certain instances, right? That used to be the exclusive jurisdiction of the zoning board. Now that's not the case anymore. So that's another benefit of you withdrawing the application, that you may never have to come back here. And if you do, you're just gonna resubmit the application, cleaned up with the things that you had to put into it, and the guidance of the planning board, probably with a memorandum of direction or something with their findings on it. That would be something you'd want, a memorandum from the town planner, say, these are my findings, and then you'd have a better path.
So I guess my question through the chair would be, if we were to table it, and then maybe potentially withdraw after discussions with the planner, would that be an acceptable course of action? Like, again, I have to speak with my client and work
Well, the only-
at this moment.
yeah, the only problem with that is that we would have to continue it in order, if we table it, it's tabled. You would have to reapply. If you continue it, to give you time to consult with the planner, we would have to continue it to a date certain and then withdraw it.
You could continue it to a date certain,
Yeah.
if that's, you don't wanna speak on authority, correct me if I'm wrong, I'm trying to infer your trepidation here. You don't wanna speak with authority, because you gotta answer to the applicant, is that right? So, yeah, I got you. You could continue it to a date certain, and he's gonna reach the same result.
But I think if we do that, what would be the legal process? I would either ask, or we would have a motion to say that we want, if you were to come back,
All those issues
we need a
addressed.
you have
And a
to, you have to
memorandum.
do everything that and I can email this to you if you like. And the memorandum from the planning board and the planner confirming either that you were granted a special use permit, that you're going to apply for one and that it's required, or if they waive it, they have the right, then we would want that letter that says that you do not have to apply.
That's a critical piece of guidance, again, but the chairman's not remanding you to the planning board because we don't have the legal authority to do that. I'm like a broken record, but I want to be clear. We're not doing that. That will
Yeah.
be part of what the board is requiring within a continuance, so you can get that stuff together. That sound right, Chairman?
Yeah, because when it's all said and done, we need the input of the planning board.
Yes.
And however that is achieved, and if the planning board requires the permit process, so be it. If it waives the process by stating some exemption, then we need a memorandum by them confirming said. And then in your conversations, the development plan review and the planner can exercise his authority accordingly. Should we just continue it? 2 weeks is enough for you to meet with the planner, I would hope?
Yeah, so I have actually already reached out to the planner and have received some emails and conversations with him in the interim. I haven't been able to submit that because obviously I wanted to submit the package as one, give you guys the time, the 3 weeks accordingly, submit
Yep.
packages in order. That work has been going on. I do have emails and conversations with him. I'll submit that formally. I'd like to discuss with him a little bit further, per our conversations tonight to make sure that we're wrapping everything up and, kind of have appropriate direction from him to deliver to you guys. So yeah, continuance of a couple of weeks for me to reach back out to him and work with him to get.
What is he saying to you? Is he saying that 6.19 doesn't apply?
So I think it does play into, and again, I have the email, I don't recollect off the top of my head, the timeline of events at which, that plays into. He's unsure from a legal standpoint of how that, when the work was completed and what you had originally brought up at the beginning of the meeting associated with the unlawful construction of something that has now, that was exempt at that point in time, but was unlawfully done, and now does not meet the requirements. So, I'll work with him and, continue to do that and have him reach out to council and people as necessary to make sure we can get this to move forward.
Because when it's all said and done, the only thing we can ask for is their formal response to whether or not is applicable or it's not applicable.
And that's coming from the town planner, because you wouldn't be before the
And
planning board.
we in no position
Yeah,
to
that's-
argue whether we agree or disagree. That's his distinction, the jurisdiction, and so, we want to continue it to the next date
Pick
certain?
a date certain
You have
that
enough
works.
time? You can, these changes are not very simplistic, these changes that,
Yeah,
you can do that in 2 days at your office, I'm sure, but.
So, oftentimes I'd love to keep it at the front as much as possible, and continuous to the nearest date certain, and then we would have to, potentially request an additional continuance based on that, information. I have done that in the past with other boards.
Well, we're at 2 weeks, we only have the solar application?
Yes.
So I don't think there's an issue with moving this out to the next, April 8th.
Yeah.
So we're gonna refer to it as a continuance. And to clarify for the record, you will provide direction to the zoning official as to the decision of the planner or the planning board with regard to the applicability of 6.19. And then you will also make, if you then proceed back to us, you will make the modifications. I'll be happy to email these to you if it helps you.
Yes, please.
Okay, if you can come up and give me your email might be on the, if not, I'll get it.
It's likely in the documents,
documentation.
but I'll make sure you have it.
Okay, all right. I don't think we need anything other than that, other than a motion to continue to the date certain of April 8th, okay. Does anybody want to engage well, I mean, it's pretty straightforward, but.
I guess I would also suggest that in order to make this legal, to the chairman's point, I think you need to ensure you're in compliance with the Rhode Island DEM AST standards, which there seem to be a lot of discrepancies that you're not meeting those requirements.
Andrew, I don't know if we have that authority, but again, that's why the planner's input is so important, because that's his, it's a very valid point, but I don't know that we have the authority to require that. But what's frustrating is if it doesn't go to the planning board,
No, but I think
it falls through the cracks, that's the problem.
But Mr. Gill's shop, so he picked up on it, you're gonna need to address that, so you should definitely write that down and make sure when you're talking to Mr. Carullo that that's something you're dealing with.
Because I think that should come from planning.
So the only reason why I mentioned it was because you said that it had to be illegal,
Lawfully permitted.
lawfully
Well,
permitted.
it's a good point. Where do you draw that line? It's a very good point, because we both know, many of us know that is a violation. So, and that's there's a little bit of money involved in that as far as remedying, and we all know there's a remedy for it, but, so, okay. So we'll take that under advisement, and that's incorporated in this already, right, with the catch basin? Is that what you were referencing?
I think that's one of many.
Okay. Well, when you come back, there's more to talk about. Okay, that being said, we have a motion to continue to April 8th. Do we have a motion?
Yep, I make a motion to continue the application ZBR 2402 to a date certain of April 8th.
And a second?
I'll second the motion.
All those in favor?
Aye.
Opposed? Okay. And then the only other item is to adjourn. A motion to adjourn?
I'll make a motion to adjourn.
Second?
Second.
All in favor? Aye.